Communication plays a very important part during any engineering and construction project. You need to have proper knowledge of the provisions under the contract and what this requires you to do. A standard form construction contract provides for the form of communication as well as the delivery or the submission of these communications. If I can refer to an example, your contract might require that a notice may be given by fax or hand delivery only. If you then proceed and give a notice of your intention to claim by email, you run the risk that the opposition may say that you did not notify your claim in the proper form required, and you run the risk that your claim will not be entertained until the proper procedure is complied with. In this case, a further risk might be that you are then too late to notify your claim due to the fact that the period of notification as provided has expired. Thus, always make sure you notify timeously and with sufficient details. It is important that the parties to a contract understand where and how any form of communication should be delivered with specific reference to the address and the office hours, etc. If your address changes during the course of the project, you need to inform the other party thereof. Contractors can encounter various obstructions or issues on site, and it's to your benefit to have a record when such obstruction and issue occurs, and especially where it might cause a delay, a loss or damage to the works, or prevent you from doing your work. It is important to record it in some form of communication. You can never go wrong to build a paper wall of records through the course of the project. To communicate and inform the other party and provide proper details and clarifications as needed or requested. This will then make it easier to communicate or negotiate a way forward. Include in your notice to claim, for example, the time you have lost and the cost that resulted as a result thereof. Follow the procedure and periods required. Refer to the correct clauses of the contract and be thorough when providing your details. This will then cancel out any misunderstanding or confusion between the parties.